Greetings, Dr. Schultz and fellow classmates, for our final discussion board. For this week's topic, we were instructed to focus on one of the amendments in the Bill of Rights and discuss the importance, modern considerations, famous court cases involved with the amendment you chose. I chose to focus on the Fifth Amendment. I plead the Fifth is a colloquial term I'm sure that most Americans are familiar with, even if they aren't quite sure about the origins of the phrase. I'll also summarize probably the most well-known court case involving the Fifth Amendment. Before I go any further, the Fifth Amendment reads, "No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of grand jury, except in cases arising in the land or naval forces or in the militia, when in actual service in time of war or public danger. Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation." In the text of this amendment, there are several important stipulations. The first is that capital or infamous crimes may only be indicted by a grand jury. The infamous crime theory comes from the Roman law infamia, which deprived the citizen of their citizenship as a punishment. In the United States versus Moreland in 1922, the Supreme Court said that incarceration in a prison or a penitentiary lends infamy to a crime. In Green versus United States in 1957, the Supreme Court ruled that infamous crimes are ones punishable by imprisonment for over a year, essentially ruling that felonies are infamous. Another important stipulation is the double jeopardy clause, which I'm sure you're all familiar with from the 1999 thriller starring Tommy Lee Jones and Ashley Judd. This clause prevents an accused person from being tried for the same charges following acquittal or conviction, and really has four distinct prohibitions: subsequent prosecution after acquittal, subsequent prosecution after conviction, subsequent prosecution after certain mistrials, and multiple punishments in the same indictment. The most famous stipulation is the protection of self-incrimination, where the phrase "I plead the Fifth" actually comes from. This portion of the amendment defines a person's rights to refuse to answer questions or give testimony against themselves. One of the most famous court cases involving the Fifth Amendment is the 1966 case Miranda versus Arizona. On March 13th, 1963, Ernesto Miranda was arrested in Phoenix on circumstantial evidence which linked him to the kidnapping and rape of an 18-year-old woman. After approximately 2 hours of interrogation, Miranda signed a confession. However, at no point was Miranda made aware of his right to counsel or his right to remain silent, and that his statement during the interrogation could be used against him. When his confession was submitted as evidence, Miranda's defender objected that it should be excluded as he was never made aware of his rights. This was overruled, and Miranda was convicted and sentenced to 20 to 30 years for each charge of kidnapping and rape. However, his defense filed an appeal to the Arizona Supreme Court. They determined that Miranda's Fifth Amendment self-incrimination clause, as well as his Sixth Amendment rights to an attorney, had been violated, leading to his conviction being overturned. Miranda was retried in 1967 without using his confession and utilizing different evidence and witnesses, and was sentenced to 20 to 30 years. An outcome of this court case is the Miranda Warnings, which I'm sure we're all somewhat familiar with. They are: you have the right to remain silent and refuse to answer questions. Anything you say may be used against you in a court of law. You have the right to consult an attorney before speaking to the police and to have an attorney present during questioning now or in the future. If you cannot afford an attorney, one will be appointed for you before any questioning if you wish. If you decide to answer questions now without an attorney present, you will still have the right to stop answering at any time until you talk to an attorney. Knowing and understanding your rights as I have explained them to you, are you willing to answer my questions without an attorney present? While this language does not have to be specifically spoken like I just did, these are the rights that a suspect must be advised of in order to exercise your constitutional rights. And these came about because of the Fifth Amendment and the Miranda versus Arizona case.